Welcome back to Savannah Car and Truck Accident Law with Andy Conn. I'm Brooke, sitting down with Andy Conn of Conn Law Firm in Savannah, Georgia. Today, we are answering the question every parent of an injured newborn eventually asks: what is a birth injury case, and does what happened in the delivery room actually give us a claim? A birth injury looks like a tragedy and feels like one. Whether it's also a legal case turns on a narrow question. Did a provider fall below the accepted standard of care? And did that failure cause the harm? We are walking through what makes a delivery room error negligence in the eyes of the law, the difference between a medical mistake and an unavoidable outcome, who can be held responsible, the OB, the hospital, the nurses, the anesthesiologist, what a cerebral palsy or birth injury cause is actually worth, and the two deadline traps in Georgia that can end a family's claim before it ever starts. So, a lot of stuff that we're going to cover today, a lot of tough topics, but we're happy to have you here to talk about it with us, Andy.
I'm happy to be here and happy to be talking about this subject, even though it's a pretty serious one. And obviously, these types of cases are among the worst that we see in this field.
Yeah, definitely very tough subject to talk about, but important so that everybody has the information that they need should something like this happen to them. So, a lot of parents assume that if something went wrong during delivery, they automatically have a case. What is a birth injury and how is that different from a birth defect?
Like with any other type of medical malpractice type claims, there is a difference between just a bad outcome that happens due to circumstances that are outside the control of your medical team versus one where there is somebody who you can hold responsible legally for falling below what's called the acceptable standard of care. And so the difference, to your more specific question of what is the difference between a birth injury claim versus a birth defect? A birth defect is just simply something that can happen due to the birthing process that has nothing to do with your medical team's actions and decision making. It's typically something that forms over the course of the pregnancy, could be something due to genetics. There's several different reasons why you might have a birth defect that is not a birth injury claim. Conversely, a birth injury claim is one where there's actually something that the medical team, the doctors, the nurses, the midwives, or the hospital policies and procedures, where they did something that caused or contributed to an injury for your child or for you. Typically, we see things like cerebral palsy, as you've already mentioned, and some other types of really gruesome, nasty sort of things that oftentimes lead to permanent injuries.
What is cerebral palsy and how can a delivery error cause it?
Put in the most simplest terms possible, cerebral palsy is something that's caused by deprivation or lack of oxygen to the child's brain. And there could be a number of different causes for that. And also, cerebral palsy, by the way, is something that is unfortunately permanent. It causes several different motor function issues and potentially cognitive issues on a permanent basis. And so, cerebral palsy can just be something that happens due to the fault of nobody. Sometimes that's just something that happens during pregnancy or the birthing process that can't be avoided for some environmental reason. Conversely, cerebral palsy can be the result of medical negligence or when a
Mhm.
doctor or other medical professional or a policy and procedure of the hospital leads to the child having a lack of oxygen to the brain. And typically, those cases are going to be when that happens during the birthing process itself. So it could be that you needed a C section emergently and there was a delay in getting a C section. It could be a lack of understanding or recognition of fetal distress. In these birthing injury cases, we have very good data. There's fetal monitoring strips that actually record specifically the time that distress happens and what was done or not done to help act as urgently as possible to save the child from having these birth defects.
Now, most people have never heard of the term HIE until after something has already gone wrong. What is HIE and why is oxygen deprivation during delivery so dangerous?
HIE is one thing, by the way, that can cause cerebral palsy, but HIE The medical term there, the acronym you're referring to is hypoxic ischemic encephalopathy. And that's just a really fancy way of saying there's a lack of oxygen getting to the brain. As you know from holding your breath underwater or things like that, there's a time frame where when you don't have oxygen going to your brain, it doesn't immediately cause brain injury. It doesn't cause brain damage, or at least not enough to where you would actually notice the difference. But there is a certain point in time where the longer you go without oxygen to the brain, the higher likelihood there's going to be brain damage. And as that goes on and on and on, the higher likelihood there's going to be some sort of permanent brain damage. And so when you have an HIE event, it doesn't necessarily mean that you're going to have permanent brain damage, but that's something that your medical team should recognize, diagnose, and treat as quickly as possible, because we're talking about minutes and even at times seconds being the difference between life, death, and permanent injury.
I appreciate you filling us in on that because I think that is an important thing that people don't think about until they're living it. So, parents want to know what actually goes wrong in the delivery room that turns into a legal claim. What delivery mistakes most often lead to a birth injury claim?
So there are a number of different things that would constitute a birth injury. Probably the one we see most often is when there is some sort of fetal distress, not either recognizing it or not acting quickly enough to alleviate the distress. And as I mentioned earlier, sort of the primary way that a medical team during the birthing process monitors whether there is fetal distress is via the fetal monitoring strips. And so when there's an issue, when you have evidence that the baby isn't doing well for some reason, it's incumbent upon that team to take action quickly. Sometimes, if it's a nurse or a midwife who recognizes the issue, they have an obligation to elevate that to a physician to make sure that they make the decision on what needs to be done next. So sometimes the case can be just as simple as the team either didn't recognize there was an issue or recognized it and didn't elevate it quickly enough or at all to a medical professional who's there to make the decisions. In that same vein, some of the other claims we see is when that has been recognized, and even if it's been elevated to a physician, sometimes it requires for an emergency C-section. And for our moms out there, my wife included, who's had an emergency C-section, it's a really scary time. But the reason why it's necessary in some births is because there is something going on that needs to be addressed immediately. And sometimes the only way to address that is to get you in the operating room and to have the C-section immediately. And when you don't do that, sometimes that is medical error that can lead to a potential recovery. There are dozens and dozens of types of birth injury claims. Another one is the mechanisms you use to get the baby out in a birth, whether you're using forceps or a vacuum. There are proper ways to use those devices and not proper ways to use those devices. Those can lead to things that might raise an issue for a medical negligence claim.
Yeah, I've definitely heard of situations where an emergency C-section was needed to either help the mom or the baby. And even my niece had a situation where they needed to use a vacuum and she ended up with a shoulder distortion. That was a pretty serious thing. So these are complications that are happening and it's important that we all know about them. Another question that I wanted to talk about is let's just say someone hears delayed C-section and knows it sounds bad, but does not understand exactly how a delay translates into permanent harm. How does a delayed C-section or fetal monitoring failure cause preventable harm?
Sometimes there's no cause for concern, there's no cause for urgency during the birthing process. But when one of those concerns arises, that's when you need to act, and you need to act quickly. So when we talk about delayed C-sections, usually the reason you're going through the C-section process to begin with is because there is some sort of emergency. Maybe those fetal monitoring strips show a high level of distress that means you need to get that baby out now, because maybe something as simple as the cord is wrapping around the baby's neck and is choking the baby. And so in those cases, this can happen. That is not the fault of your team typically when the cord causes something like that. But when they recognize something, or when they should recognize something like that is happening, it's incumbent upon the medical team to act immediately. And that means to get you into the operating room, perform the C-section when indicated as quickly as possible. Because when that cord wraps around a baby's neck, if you get the baby out quick enough, then there won't be any harm. But if you delay, then that can lead to those things we mentioned earlier, the lack of the oxygen to the brain. It can lead to death, unfortunately, in some cases. It can lead to permanent injury and brain injury, like cerebral palsy that we also mentioned earlier.
That's definitely an important topic. A birth injury case is won or lost on two questions. Did the provider breach the standard of care, and did that breach cause the specific injury? Both are answered by qualified experts reading the record, not by the family and not by the lawyer. Families often think standard of care is a vague idea. They do not realize it is a legal benchmark with a precise definition. What is a standard of care for an OB and the delivery team as well?
I'll actually push back just a little bit on that point because I did have one case where one of the family members involved was herself a midwife. So sometimes the family is able to give you some opinions or some advice as to what's going on there. Midwives are able to read fetal monitoring strips. They understand those standards. So sometimes you get lucky enough where you have clients that do have some experience that help you out. And I have had examples of that in the past. But typically, you're right. Family members aren't going to be able to, in any reliable way, read fetal monitoring strips or to unpack the medical records to understand, was this due to a bad outcome that we couldn't have avoided, or was this due to medical negligence? And so in a birth injury medical malpractice case, you need a team of experts. Typically, you're always going to have an OB doctor, the doctors who deliver babies. You're going to need one of those to walk you through what are the standards in this particular case? What does the evidence say? What do the fetal monitoring strips show? And based on the evidence, can we say that this doctor or this nurse or this midwife violated or fell below the standard of care? A second expert you often need, because we talked about, again, brain damage is a common issue we have in birth injury cases and in cerebral palsy. Typically, you're going to want to get a pediatric neurologist because you don't only have to prove that the doctors and nurses screwed up or that the hospital screwed up. You also have to prove that the breach of the standard of care caused the injuries. And so it's incumbent upon a good qualified trial attorney to hire the right experts to be able to say, yes, they breached the standard of care, and another expert to say, and it caused the CP, it caused the HIE, or any one number of other acronyms that we might use to describe permanent injuries in these birth injury cases. And then we talked about this in other episodes. Usually when you have a birth injury case and you've got a permanent injury, it's something that's going to live with this child and with the family for the rest of their lives. And so what are the costs associated of retrofitting your house? What are the costs associated with the medical care and the equipment that you need for the rest of your life? That's where you need a qualified life care planner to be able to basically show what those costs are going to be over the course of time. And then finally, you need an economist to be able to reduce that into today's terms. How much does that cost today so that we can be taken care of, this child can be taken care of for the rest of his or her life?
A lot more that goes into that people wouldn't necessarily think about at the first glance. The hardest thing for a family to accept is that even when something clearly went wrong, proving who caused it is a separate fight. How is it proven the provider, not nature, caused the injury?
You might have a case where someone screwed up and they didn't do what was right, but that doesn't necessarily mean you have a case because you still have to prove that this wouldn't have happened anyways. So, particularly when it comes to brain injuries where there's a lack of oxygen to the brain, sometimes circumstances would have caused that to be the case anyways. And so again, you need somebody who understands these types of cases, is able to unpack it, hire the right experts to unpack it, to decide, is this something we can prove that actually was a result of the negligence? Even if there was negligence there, that's not where we stop the investigation. And the reason why that's not where we stop the investigation is because that's not where it stops what you have to prove at trial down the road in the case. And so before you say, yes, this is a case, you want to say, can I prove this to a jury?
People assume one doctor reviews the case and that's enough. They don't realize how many experts a birth injury case actually requires. We've talked a little bit about the experts needed in cases in different episodes. We've even talked about it a little bit already this episode, but what experts does a birth injury case require? I'd love to understand that a little bit better so that our listener has a full grasp on it.
So, in addition to some of the ones we've already talked about, again, the delivery doctors, you need those. The pediatric neurologists for causation purposes, you need those. You might also consider hiring a nurse because if there are nursing claims, you want a nurse who handles birth situations themselves to talk about what are nurses supposed to do. There might also be a situation where a midwife, which is considered in between a nurse and a doctor, their capabilities in delivering a baby. If there's a midwife involved, you might also want to involve a midwife as an expert to help you evaluate a case. Now, one other area, and I don't think that every firm does this. This is something that when there's evidence of it, we certainly like to involve that. But I like to get involved what's called the hospital administration expert. Because sometimes when a doctor or a nurse does something that leads to a birth injury, it's not always because of something that they did themselves, but because of a policy or a pattern in practice of the hospital or the organization that's in place. If you've got an institutional claim, if there's a pattern or a practice, or perhaps the hospital has understaffed the nursing or the doctors, or they don't have a very good means of communicating between the different providers, then a hospital administration expert can be vital to these cases and showing it wasn't just because a doctor made the wrong decision. It's because that decision was basically taken out of her hands because the hospital didn't have the appropriate amount of nurses, or the hospital didn't have any means of communication, or the hospital did a number of other things that led to the birth injury.
What qualifies somebody as an expert?
In Georgia, and frankly, in most states, in medical malpractice setting, you have to have practiced in the particular area that is involved in the case for 3 of the 5 years prior to the incident. So if the incident happens in January of 2020, then going back to 2015, that expert would have had to have worked in the same field for at least 3 of the 5 years. Now, that's just the bare minimum for getting in the door. I typically like my experts to have experience going way further back than just 3 of the past 5 years. I like experts with 10, 20, 30, 40 years of experience at times. You don't want to just meet the bare minimum. You want to be sure that you've got someone who is incredibly qualified, who's going to present well to a jury, who's not going to be condescending to a jury, someone who's an educator, as well as someone who's qualified and is giving the honest truth about what the medicine dictates that doctors, nurses, midwives, and others should do in a particular situation.
That's good to know. We talk about experts a lot. So I was just curious as to what that bar looked like and what made somebody an expert. Most families have no idea the answer to the entire case may already be sitting in a stack of hospital records. What medical records and monitoring strips tell the real story?
For different types of med mal cases, there's different records that are sort of important. For birth injury specifically cases, it's going to be those fetal monitoring strips. That's not the entire truth because what's also important is with that information, what did the medical staff do? And so there are other medical records with timestamps that you need to be able to piece together. Here's the information they had at their disposal. What did they do with it? Right. Other things that people maybe don't know is that there's data behind the data, right? There's what's called metadata, or in the medical context, what's called an audit trail. And audit trails basically show you not only what information was plugged into the system, but when it was plugged into the system, by whom it was plugged into the system, and whether those medical records were changed. We've encountered doctors and nurses in the past who realized that they screwed up. And so they decided to try to take things into their own hands and change the medical record so that they would not be exposed to medical liability. The problem for them was we were able to see that. I had one doctor one time who when I got the chart, the medical chart, it said exactly the opposite of what my client was telling me. And I had a hard time deciding. I was like, well, this person's saying X, but the medical records say something completely opposite of what they're saying. And so once we were able to get the case in suit and get the audit trail and see the data behind the data, I found this doctor had changed the records, but he hadn't just changed the records. By the way, it was the day after we requested them is when he changed the records. But I was able to show that the day after he changed the records, 10 minutes after that, he had a moment of morality and clarity, and he actually changed them back to what they originally were. And then 10 minutes after that, I guess he decided that no, he didn't want to play that, changed them back to the falsified records. And you can see all of this on the audit trail, minute by minute, what's happening, who's doing it, what they're doing, what they're changing. So for all those doctors out there, maybe think twice before you change your records.
That's crazy. That's the type of stuff that you see on like Grey's Anatomy or something. But it's so sad that's happening in real life. And I always appreciate you sharing like real life stories because I think that helps people put some of this stuff into perspective. Now, Georgia has a filing requirement most states don't, and missing it ends the case before it starts. What is an affidavit of expert and why does Georgia require one to file?
I'll give you the statute there. It's O.C.G.A. 911 9.1. It's very important. Many states have adopted similar statutes than Georgia. Most states that I've practiced in, actually every state I've practiced in a medical malpractice context, does require an expert affidavit. And all that means is, like a car wreck, you can file a lawsuit against the person who hit you. But in a medical malpractice case, you have to have a qualified expert in the same field as the person you're suing to sign what's called an affidavit of merit, saying that this doctor did violate the standard of care and it caused injury or death to the person that you're representing. And so, again, it's that same standard. The expert has to have the same level of experience for 3 of the 5 years preceding the incident itself. And there's several different things. And one thing that you want to make sure that you're doing is that you're hiring a qualified attorney who understands how important these affidavits are, because there are several different pitfalls. If you don't handle those perfectly and make sure you're dotting all your I's, crossing all your T's from Georgia's statute perspective, it can be a reason why a court can throw your case out if you miss just a small technicality on those. So it's important to have an attorney who understands these cases, who works with experts who are qualified in signing those affidavits to make sure that your rights are preserved.
Birth injury cases are among the highest value malpractice claims because the harm lasts a lifetime. Georgia adds a second layer. It is one of the few states with no cap on non-economic damages, which changes the math on a catastrophic case. People know birth injury cases can be serious, but they do not always understand why the numbers are so much larger than other malpractice claims. Why are birth injury cases among the highest value malpractice claims?
There's a number of reasons why birth injury cases are amongst the highest. The first and foremost is just that children being born are among the most vulnerable types of claims that there are. There's nothing that this newborn or soon to be born child can do to protect themselves. And so, literally, it's a life and death situation or permanent injury sort of situation with these children who can't do anything to fend for themselves. So part of it is just that human aspect of it, that people understand you can't blame the child for the birth injury. And so that's part of it. The second part is the economic damages that you mentioned are typically just astronomical because it costs a lot of money oftentimes when you have a permanent injury, because that means medical appointments recurrent for the rest of your life. That means at times wheelchairs or crutches or potentially specialists that you have to work with or prosthetics. It could mean retrofitting your house or getting a new house entirely at times, right? Because some houses just don't work. If it's up a big set of stairs and it's someone who can't walk, then that's not a house you can live in anymore. And so we talked about life care planners, but oftentimes the cost of lifetime care for permanent injury is in the tens of millions of dollars. And then the third aspect of these cases that typically drive why you see these higher values in settlement or verdicts is because of the non-economic aspect of things. When you have a permanent injury, the only form of damage isn't just your medical cost and retrofitting your house or getting a new house. It's what have you missed out on in life, right? If you have CP, doesn't mean you can't have a great life. It doesn't mean that you can't still have value in life and still have love and enjoyment in some aspects, but typically it's going to be severely impaired. A lot of these people are never going to play sports. They're never going to get to go ride on the jet ski at the lake. They're not going to be able to do many of the things that just give life value that people, when they think about things that make them happy, some of these children, unfortunately, are never going to be able to experience those types of things. And so really those three aspects together drive the value of birth injury cases.
Yeah, that non-economic piece is huge. It should be the first thing that people think about in a case like this.
And by the way, shout out to Georgia's Supreme Court that there was a challenge, by the way, to the non-economic non-caps we have in Georgia, because the people of Georgia, again, have decided we value life, we value the ability to live life, and we don't want caps in the state. Recently, the medical community challenged that against, it went all the way up to the Supreme Court. And just last month, our Supreme Court said, no, we're siding with the people of Georgia, 9-0 decision, unanimous, that there will not be caps on damages in medical malpractice cases in Georgia. And so shout out to our Supreme Court for backing the Georgian people over the insurance industry that was pushing this reform.
My next question was going to be, how does Georgia's no cap rule affect a catastrophic birth injury value? What effect does that have on these cases?
Well, that just means that you get to present your case. You get to ask a jury of 12 members, which, by the way, in Georgia, you still have to have 12 out of 12 jurors agree with you. If you have just one that doesn't agree with you, you're either not going to win or it's going to severely limit your recovery. And so when we hear about these nuclear verdicts at times, what people are forgetting is there are 12 strangers who unanimously decided that was the value of the claim. And so not having caps in Georgia just allows our Seventh Amendment right to be realized, which is we value the right to trial by jury. And 12 strangers unanimously come together and say that this child who has a permanent injury, that maybe the value of that is 30, 40, 50, 60 million dollars. That's a whole heck of a lot of money. And I get that. But to try to say that our legislature can decide that it's only worth $350,000, which is what they tried to do, quite frankly, I think it's disgusting, especially given the context that we value the jury system. 12 strangers are the ones who heard the evidence and came to that conclusion.
Now, we've talked about this in past episodes and a little bit today as well. A lifetime of therapy and care, it sounds really expensive, but families want to know how you actually put a number on it. How are lifetime of care and therapy costs calculated?
Yeah, and we talked about this a bunch in the past, but that goes back to the life care planner. Now, that's particularly important in birth injury cases, which I'm glad you've brought it up in this context, because sometimes you have life care planners when an adult has a permanent injury, but it's even more crucial in a birth injury case because you're talking about not the rest of your life planning, you're talking about your entire life. This child who knows what their needs are going to be, but to have someone who's qualified, who can go through, understand the injuries and what those injuries dictate are going to require their future medical costs and needs over the course of time, it's really important. And so in this context, having a good life care planner who's got subject matter experience, meaning they've dealt with other children in birth injury cases, is really important.
Now, it seems impossible to put a dollar figure on what a child would have earned when they've never worked a day in their life. We didn't know if the child was going to be a lawyer or if they were going to just work at a restaurant. How is lost earning capacity valued for a child who can't not yet work?
You are entitled not only to your medical cost and your loss of life, but your loss of future earnings and potential earnings in the future. It's hard, right? Because what we're doing is we're trying to In some ways, guess what this child would have earned? Because the child has never, when it's a birth injury case, has never held a job. But having a qualified economist expert who can evaluate this is crucial. And what they'll do, an economist in these scenarios, is they'll go through and look at demographic information. They'll look at the area of the country you look in. They might look at your parents and grandparents. What did they do for a living? Because if your parent or grandparent was a lawyer, as you mentioned, doesn't mean the child's going to be a lawyer, but there is a higher likelihood that they are going to be in a field that's similar to that. And so it's like with anything else, an economist will put together several different options of here are the range of possibilities that this child could have enjoyed in terms of lost earnings over the course of his or her life. And then usually it's then up to the jury to decide, what do we believe this child could or would have done? And what do we feel comfortable awarding to this family or this child for these injuries?
Families want to understand what falls under pain and suffering for a child and when the more serious damages come into play. When are punitive damages possible, and what economic or what non-economic harm does a child's case capture?
Those are really two things, right? So pain and suffering doesn't just mean physical harm, right? It's conscious mental anguish too. So it could mean the things that we mentioned earlier. It can be being wheelchair bound because of CP and watching your friends play baseball or basketball or tennis or swimming and you not being able to do that. That goes into the non-economic damage package. And typically when we're talking about birth injury cases, those are the drivers of value. You talk about punitive damages. There are cases in birth injury cases where that is recoverable, but it's very uncommon. Punitive damages, you have to prove a higher standard. You have to prove by clear and convincing evidence, which is higher than the typical standard, that someone did something with a conscious indifference to the consequences or intentionally. Oftentimes when a doctor or a nurse screws up, it's not intentional. And so it's very difficult to prove that. Now, the one exception to that and the one context you might see a punitive damages claim in a medical malpractice context, and specifically a birth injury context, is if there's a pattern in practice of the institution, right? Maybe this is the first time this doctor has screwed up, but maybe it's happened time and time again at this hospital because that hospital didn't have a very good policy and refused to change the policy when they had prior injuries and prior deaths to save lives in the future. That's when you might have a punitive damages claim under Georgia law in a birth injury case.
Two things decide whether a strong birth injury case ever gets heard: the filing deadlines, which work differently for a child, and getting the right defendants and experts in early. This segment covers both and what a Savannah family should do first. Most parents assume the clock on a birth injury works the same as any other injury claim. It doesn't. How long does a family have to file, and how does the deadline differ for a child?
So what you're talking about is the statute of limitations, which typically in Georgia is 2 years from the date of that the injury occurs. Okay. For birth injury cases, though, for the child's claim, you actually have 2 years from their fifth birthday. From a birth injury claim, that's really 7 years. It's not always exactly 7 years, but a general rule is it's about 7 years for the child with their parents' basically approval to bring that claim. The thing where people can get hung up and where you need to be careful is part of the claim in a birth injury case is actually the parent's claim. The parents are the ones who cover the medical bills. So any of our parents out there like me, when you go to the doctor with your child is not the one who has to pay the doctor's bill. It's you, the parent, right? And so for any of the medical bills that are associated that you can recover for in a birth injury case, you still have that 2-year statute of limitations. So you still might need to bring your claim if that's a significant portion or a portion you want to recover for in that 2-year period. But for the child's claim, which again goes to the future, like the lifetime of medical care, the pain and suffering, the loss of enjoyment of life, all of those different things, you've typically got 7 years. Georgia does have a 5-year statute of repose, meaning even if there's some exception to the 2-year statute of limitations, After 5 years, you typically can't file a medical malpractice claim. But again, that does not apply to the birth injury claims for the child's claim, because you do have 2 years from the child's 5th birthday to file the claim. The takeaway there is hire an experienced attorney who does these sorts of things, because most attorneys don't even understand the statutes of limitations as it relates to birth injury cases. So you want to have somebody qualified. And by the way, speak to them as soon as you're comfortable doing so, so that those rights are preserved.
Absolutely. A lot of families only think about suing the doctor, but they don't realize that the hospital itself can be a defendant. How do hospitals and corporate defendants enter a birth injury case?
That's a huge mistake if you're hyper focused on the doctors and nurses, because oftentimes, yes, a doctor or a nurse in a split decision might make the wrong decision, or they might not act quickly enough in the 5 to 10 minute interval that matters. And that's important, and that can expose them to liability in a medical malpractice sense. But typically, the institutional claims are much more damning, because the institutions typically have months, years, decades, even at times, of knowledge about a particular issue at the hospital or institution that's not being fixed. And so when you talk about with the jury these sorts of issues, you're talking about really conscious decisions, not split second decisions that are leading to serious injuries and deaths. And so to not consider the institutional claims, if there's facts that support it, I think is a huge mistake. And it's why, again, you need a really competent, experienced trial attorney who handles birth injury cases to evaluate whether there are institutional claims as well.
You always need an expert. Families in Savannah want to understand what they're actually signing up for when they decide to pursue a case. What does the litigation process look like for a birth injury claim in Chatham County?
I'll just be honest with you. These are not quick settle type cases. They are hotly disputed. There's a lot of moving parts, a lot of complexities. And even though you might find an expert who says that this was a breach of the standard of care, the defense will find someone, even if they have to talk to 10 different people before they find the one person who says the doctor didn't commit malpractice. They will find that person, and they will make life very difficult. These cases often take a very long time to litigate. It's measured in years, not months. And when you do bring one of these claims, one conversation I always have with my clients is it's not going to be a simple process. It's going to take some time, and we'll do our best to push it as quickly as possible. But there are just some factors that you can't control that do cause these cases to take a little bit longer than others. The first step is evaluating whether it's a case at all with those experts that we mentioned earlier. Mm-hmm. And if it is, having an expert, a qualified expert, sign an affidavit of merit to put together a lawsuit and to file that with the court. After that time period, that's when you get into that litigation stage that does take typically years before you get to a jury trial.
Winning a case and actually collecting money are two different things. And most families don't know the difference until, unfortunately, it's too late. How does insurance coverage shape what a birth injury family can actually collect?
Just yesterday, Conn Law, we were able to secure a $40 million judgment against an insurance company. And now is when the process starts for us to try to go collect that money. So one thing people don't realize is just because you get a judgment for a lot of money doesn't mean you're actually going to collect on it. This particular case, we certainly think that we'll be able to, at least to some extent. So we'll see how that goes. But it's important to have someone who understands that concept of, you could have a doctor who screwed up. You could have an expert that says that the screw up caused significant permanent injuries. But if there's no one to pay the bill after a judgment, then that's what's really the point of this, is to be able to provide for some sort of compensation at the end of the day. Even if your motivations are for justice, which most of my clients are, the best way to serve justice is by hitting companies where their pocketbooks are, or insurance companies, so that policies and procedures change. In the medical context, insurance policies are more intricate than in most other types of insurance policies. There's things called consent requirements, where doctors have to consent before an insurance company can even decide whether to pay a claim. And so there's a lot of different intricacies that you need an experienced medical malpractice trial attorney to be able to walk you through, even if you have all the other good stuff, do we still have a case? Is there somebody who's going to be able to pay the bill at the end of the case?
Yeah, that's super important. And again, something that people don't really think about at all. So I'm glad that we dove into that. A parent suspects something went wrong, but has no idea where to even begin. For parents who suspect a delivery error, what is the first step?
The first step, honestly, is contacting an attorney who understands these cases, because me and other attorneys who do the same thing, the consultation is free. It's not something that you might think, I don't want to pay thousands of dollars to find out I don't have a case. Luckily, you don't have to do that. We work on contingency fees. We, as the attorneys, take the risk on the front end, and then we share in the recovery on the back end if there is a recovery. But the first thing they should do is just talk to an attorney. See if they have a case. Definitely do your research. Go look at the attorney's website, do some due diligence, see if they have results, settlements, verdicts, things of that nature in the subject matter area that you're getting an opinion on. And if they do, then ask them to evaluate your case and have them go through the medical records for you. Have them hire the experts on their bill or my bill so that you're able to fully evaluate whether you do have a birth injury claim.
For sure. And something that I've learned from you is to do it sooner than it feels necessary.
I promise you that the institution and the doctors and the nurses, their attorneys are already working for them before you even decide whether you want to have it evaluated by an attorney. So definitely the sooner the better.
If your child suffered a birth injury or was diagnosed with cerebral palsy and you believe a delivery room error was to blame, call Conn Law Firm at 912-373-8642 or visit connlawfirm.com to talk to Andy Conn directly. The consultation is free. Thanks for listening to Savannah Car and Truck Accident Law with Andy Conn. We will see you on the next episode.